Secondly, if you give a notice saying that you need it for personal use and then you rent it to somebody else for a higher rent or you list it for sale, then that's considered as illegal notice.
Hey everyone, it's Lawrence Mack here from Remax Realtron. I'm here today with Dheeraj Bhatia from Madam Sir. He's been a barrister and solicitor for more than 10 years in Canada, and we're here today to talk about tenant evictions. Thank you for joining me today.
Thank you for having me. It's a pleasure.
Oh, excellent. Well, so the main question I have is that I had an investor of a rental condo and had a tenant in there, and they're thinking about selling the condo, but there's a tenant in there already, and they're wondering, like, can I just tell them that I'm going to be selling them and then give them, 60 days notice? Is that possible?
So, Lawrence, what is the major misconception that is among people is, realtors and common people is, that once the fixed 1-year term ends, people can just give 60 days notice and evict the tenant. That is not true. So, the Residential Tenancies Act provides that once the 1-year term ends, whether it is 1 year or 2-year term, if it is not renewed by a fresh lease agreement or a renewal agreement, then the tenancy is stated to be renewed automatically on a month-to-month basis. So you cannot evict the tenant on the basis that you are selling the unit. The only way you can evict the tenant is either if the tenant does something illegally, that is non-payment of rent or illegal use of the property or whatever, or violates any other terms of the lease. In that case also you have to give him notice to correct. If he corrects his default, then he's back in good standing.
So if he just pays it again, then it's okay, and then it's just back to normal?
Yes, or if he is using the unit or the freehold house for a larger number of people than is allowed, then if he corrects that, then he's in good standing. The only way you can evict him, either if the landlord wants the unit for personal use, and the personal use is defined under the Residential Tenancies Act as used by the landlord, by the spouse, or the immediate family, which includes the children. It does not include cousins or uncles or aunts. That's what some people do. So in that case, the landlord can give, after the end of the term, can give 60 days notice to the tenant to evict the property. Now there's another rider to it. Once the notice is given, that does not automatically guarantee that the tenant would evict the property at the end of the notice period. So how some people do is that, say for example, we are in April, right? So April 30th is the last day of the term. People give 2 months notice, which is 60 days before the end of April. Say you give 1st of March, and they think, oh, 30th of April the tenant will go, we can rent it out on 1st of May. That sometimes may not be possible, because the tenant, even though it is the landlord's right to evict for personal use, the tenant may object, may go to the landlord tribunal and drag on the matter for months. That's first thing. Secondly, if you give a notice saying that you need it for personal use and then you rent it to somebody else for a higher rent or you list it for sale, then that's considered as illegal notice, and the cost is up to $10,000 in penalties and fines.
That's quite a bit.
Yeah, but that does not mean that there is no other recourse. The recourse is that the landlord, instead of giving notice, can list the property for sale, and after the agreement is signed, then he can give notice that the buyer requires the unit for personal use. The same conditions apply, that the buyer can requires it for personal use or the use of the spouse or the immediate family, being the children.
So in that case, the buyer is the one who's actually saying, I'm using it for personal use, so then I can give notice.
Give notice, yes. But in that case, the realtor and the clients need to assure that when they accept an offer, there should be a clause therein in which they cannot promise weekend possession, firstly. Secondly, there should be a statement from the buyer. It could be added in a Schedule A, that the buyer represents and warrants that the buyer requires the unit for personal use, and the tenant undertakes to give notice. The landlord undertakes to give notice to the tenant, as required under the Act. But you cannot still promise weekend possession at the time of the closing.
Because you can't control the tenant. The tenant just sits there, squats, tries to complain to the LTV or something. Nothing can happen. Then.
Nothing can happen. So this is what is required, which some people miss, and sometimes the sellers are in breach of the contract.
Wow.
Yeah.
That's a lot of things to really think about when in that case. I've also heard that some landlords actually just say, we're renovating the place, so basically, can you please move out? And then they try to sell it afterwards. Is that legal?
So here's the thing. Yes, you can renovate, but you cannot just renovate on a whim. So first of all, you cannot renovate during the term of the lease. So within the term of the lease, you can only renovate if the tenant demands any renovations, that the roof is leaking or there are cracks on the wall or something like that. But if, say, for example, it's a residential complex and the lease has come to an end, the tenant is continuing on a month-to-month lease, and the landlord has to make major renovations in the unit. So then they can give notice under the act that we are doing major renovations in the unit for which vacant possession is necessary. So the Residential Tenancies Act says that only those renovations require notice. Notice is allowed when it requires vacant possession for the renovations to continue. Then they can give notice. The notice has to be a minimum period of 120 days, not the 60 days.
Okay.
And secondly, they can let the tenant know that you have a right of first offer, that after the renovations are complete, the tenant can say that I want to lease the unit back.
Right.
The tenant has the right of first refusal, but the tenant has to give that notice on the day of the termination of the tenancy or before. If the tenant does that, when the renovations are complete, whether it is 2 months, 6 months, or even 1 year, the tenant can occupy the renovated premises at the same rent. At the same rent or the increased rent as allowed under the rent control guidelines. You cannot increase the rent just because the unit has been renovated.
Right.
It's nicer and it's more luxurious. You cannot do that.
Okay.
Yes.
Wow, that's quite a bit of information. So in summary, it seems like you can't just evict a tenant willy-nilly. You have to have a reason, usually personal use, or they're doing something illegal. You have to give them the proper amount of notice.
Yes.
And when you are selling your unit, the buyer ideally would warrant that they're needing it for personal use so that you can evict the tenant properly. And you can't just renovate and kick them out. If you do, you can renovate and then you can give them the right of first refusal to come back and to rent it at the same market rate.
At the same price. And also just to mention herein that when people think notice, a notice by email is not sufficient. You have to give notice on the proper forms which are provided on the landlord and tenant tribunal website.
Right.
Yes.
So just make sure that you're using the proper form and make sure you have a professional guiding you throughout the process, whether it's a realtor or a lawyer, so that you're doing everything properly because you don't want to have any trouble with the government.
Yes. And to the audience, since Lawrence is the one who's doing this webcast, you can always contact Lawrence or you can contact us and we'll be happy to guide you.
Yeah, that sounds great. So I think that answers all the questions I have today for that particular topic, Dheeraj. Thank you very much for joining us. And if you have any questions about tenant evictions or that kind of thing, just contact Dheeraj, Bhatia anytime. Thank you.
Thank you so much.